On February 6th, a three-judge panel in the Fifth Circuit issued a ruling in U.S. v. Peterson stating that suppressors are not arms and therefore are not protected by the Second Amendment. To recap our position, we absolutely could not disagree more. Suppressors are in fact arms, especially when you consider that the act that is restricted is the use of a suppressor in conjunction with a firearm. Let me put that in perspective. There are no restrictions on the use of suppressors for automobiles. In fact, their use is required. We may not call them silencers or suppressors, but at the end of the day, a muffler is the exact same thing, just used in a different application. Shortly after the February 6th decision, the Defendant's Counsel brought on Cooper and Kirk, the same law firm that the ASA Foundation and Silencer Shop retained for the legal challenge to the ban on suppressors in Illinois, to petition the Fifth Circuit for an en banc review. If you're not familiar with en banc reviews, it's basically a special procedure used by the courts to engage all of the judges within the circuit to review the case at hand. Well, on March 17th, the acting U.S. Attorney for the Eastern District of Louisiana issued a response in which he argued against the petition for en banc review and asserted that suppressors are not arms and therefore should not be protected by the Second Amendment. Needless to say, we immediately pushed back, asking the administration to reconsider their position. As if on cue, on March 18th, ASA General Counsel Michael Williams participated in a litigation update on the Peterson case with the Federalist Society, during which he explained the many reasons why suppressors should be protected by the Second Amendment. It's about an hour long, but trust me, it is well worth the watch. Well, it appears that someone within the Trump administration thought so too, because following our calls for the DOJ to reconsider its stance on suppressors, on March 20th, the government filed a new motion asking the court for a 30-day delay on the ruling for en banc review to give the government time to reevaluate its position. Fast forward to March 24th, and Chad Mizell, Chief of Staff to Attorney General Pam Bondi, put out this tweet on X. Protecting the Second Amendment rights of law-abiding citizens is a high priority for AG Pam Bondi. To that end, the department will be reevaluating some of its recent litigation positions on Second Amendment issues, including silencers. I'm not sure it's possible to underscore how big of a win this is. The Chief of Staff to the Attorney General put out a public statement acknowledging that the DOJ is reevaluating its position on suppressors. If you would have told me 6 months ago that this would happen, I would have told you you were crazy. And thankfully, I would have been wrong. Our community owes Attorney General Bondi, Chad Mizell, and the Trump administration at large a huge debt of gratitude for their leadership prioritizing our Second Amendment rights. It is truly a refreshing departure from the previous administration, who did everything they could to restrict and erode our constitutionally protected right to keep and bear arms.